Thank you very much indeed. Right, I welcome members to the 9th meeting in 2014 of the Delegated Powers and Law Reform Committee and ask members to switch off mobile phones, please. Agenda item 1 is a decision on taking business in private, because it's proposed that the committee takes item 7 in private. This is to allow us further consideration of the delegated powers provisions contained in the Revenue Scotland and Tax Powers Bill to inform the drafting of the committee's report of the bill at stage 1. Does the committee agree to take this item in private, please? We do. Thank you. Okay, it's worth noting at this point, of course, that Stuart Stevenson has sent his apologies. He's been here for the briefing, but he has another business, so we do have Stuart Stevenson's apologies. Thank you. That takes us to agenda item 2, instruments subject to affirmative procedure, the Agricultural Holdings Scotland Act 2003 Remedial Order 2014 draft. Members will recall that the committee had previously considered a draft of this order during its pre-laying consultation stage in January and February of this year. A revised draft of the remedial order has now been laid before the Parliament for approval under the affirmative procedure, along with an accompanying statement of observations and reasons as required by the Conventions Rights Compliance Scotland Act 2001. Statement comments on any written observations submitted within the consultation period, including the report submitted by this committee. The committee is required to scrutinise the draft order in the same manner as it would any other instrument, applying the reporting grounds set out in Rule 10.3 of Standing Orders. Members will have seen the revised draft order and the briefing paper from our legal advisers. Do members have any comments, please? Does the committee agree to report that it is now content with the draft remedial order and the accompanying statement of observations and reasons? Thank you very much. Agenda item 3, instruments subject to negative procedure. The National Health Service Superannuation Scheme Scotland Amendment Regulations 2014, SSI 2014-43, and the Teachers Superannuation Scotland Amendment Regulations 2014, SSI 2014-44. Our legal advisers have raised the same points in relation to both of these instruments. The committee may consider that there has been unjustifiable delay in laying of the regulations before the Parliament, as they were made on the 13th of February 2014 and laid on the 24th of February. While the delay does not affect the validity of the instrument, it also amounts to a failure to comply with the laying requirement in section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010, that an instrument must be laid as soon as practicable after it is made. The committee may consider that the period of delay in laying the regulations is unusual and is not satisfactory. However, in its response to the committee, the Scottish Government has offered apologies and notes that steps will be taken to try to ensure the omission is not repeated. Does the committee agree to draw both sets of regulations to the attention of the Parliament on the committee's reporting ground D, as there has been an unjustifiable delay in publication or laying of the instrument? And does the committee also agree to draw both sets of regulations to the attention of the Parliament under ground J, as there has been a failure to comply with the requirement that the instrument must be laid as soon as practicable after it's been made? John.
Thank you. Yes, I agree with that. I'm also disappointed that the presiding officer was not notified, as should have been the case. I assume that the apology will also include an apology to her.
I imagine that's the case, but thank you. Mike.
I think it seems to me that there's a case for both governments to apologise, given that some of the delay at least was due to the UK government.
Are we content with those observations? Thank you. Does the committee agree to note, however, that steps are being taken by the Scottish Government to ensure that the omission is not repeated? I think that's actually quite important. Thank you. No points have been raised by our legal advisers on the Coatbridge College Transfer and Closure Scotland Order 2014, SSI 2014-52, nor on the Town and Country Planning, Tree Preservation Order and Trees in Conservation Areas Scotland Amendment Regulations 2014, SSI 2014-53, nor on the High Hedges Scotland Act 2013, Supplementary Provision Order 2014, SSI 2014-55, nor on the Roadworks Inspection Fees Scotland Amendment Regulations 2014, SSI 2014-56, nor on the Personal Injuries NHS Charges Amounts Scotland Amendment Regulations 2014, SSI 2014-57, nor on the Scottish Roadworks Register Prescribed Fees Regulations 2014, SSI 2014-58, nor on the Firemen's Pension Scheme Amendment Scotland Order 2014 SSI 2014-59, nor on the Firefighters Pension Scheme Scotland Amendment Order 2014 SSI 2014-60, nor on the National Health Service Optical Charges and Payments Scotland Amendment Regulations 2014 SSI 2014-61, nor on the Police Pensions Contributions Amendment Scotland Regulations 2014 SSI 2014-62, nor on the non-domestic rating valuation of utilities Scotland Amendment Order 2014 SSI 2014-64, nor on the carers waiving of charges for support Scotland Regulations 2014 SSI 2014-65, nor on the community care, joint workings, etc. Scotland Amendment Regulations 2014 SSI 2014-66, nor on the Police Service of Scotland Performance Regulations 2014 SSI 2014-67. In relation to the Police Pensions Contributions Amendment Scotland Regulations 2014 SSI 2014-62, however, the committee may wish to write to the Scottish Government to seek an update on the plan to consolidate the police pension scheme in the Police Pensions Regulations 1987. Is the committee content with these instruments, please? Content. Thank you. Agenda item 4, instruments not subject to any parliamentary procedure. No points have been raised by our legal advisers on the High Hedges Scotland Act 2013 Commencement Order 2014 SSI 2014-54. Is the committee content with this instrument, please? Thank you. Agenda item 5 is the Bankruptcy and Debt Advice Scotland Bill. This item of business is consideration of the delegated powers provisions in this bill after stage 2. Members will have noted that the Scottish Government has provided a supplementary delegated powers memorandum and will have seen the briefing paper. Stage 3 consideration of the bill is due to take place on Thursday the 20th of March. The deadline for lodging amendments is 4:30 this Friday the 14th of March. The committee may therefore wish to agree its conclusions today. Does the committee agree to report that it is content with the provisions in the bill which have been amended at stage 2 to insert or substantially alter provisions conferring powers to make subordinate legislation? Indeed. Which brings us to agenda item 6, which is the Courts Reform Scotland Bill. The purpose of this item is for the committee to consider the delegated powers in the Courts Reform Scotland Bill at stage 1. In considering the bill, the committee is invited to agree the questions it wishes to raise with the Scottish Government on the delegated powers in the bill. It's suggested that these questions are raised in written correspondence. The responses received will help to inform a draft report on the bill, and the committee will have the opportunity to consider the responses at a future meeting before the draft report is then considered. Section 2.1 of the bill confers power on the Scottish ministers to create or abolish sheriffdoms or sheriff court districts and to change the boundaries of such sheriffdoms and districts. In addition, it enables ministers to open new sheriff courts, change the location of sheriff courts, and to close sheriff courts. Scottish ministers may only make an order after receiving a proposal from the Scottish Courts and Tribunal Service, who may only make a proposal themselves with the agreement of the Lord President. The Scottish Courts and Tribunal Service is also placed under a duty to consult parties who are likely to have an interest prior to making such a proposal. If following such a proposal the Scottish ministers decide to make an order, they must have regard to the proposal and may make the order only with the consent of the Lord President and the Scottish Courts and Tribunals Service. The power updates and reorders the powers to alter sheriffdoms and sheriff court districts in sections 2.1 and 3.2 of the Scottish Sheriff Court Scotland Act 1971. Under these provisions, the Scottish ministers are only able to make changes with the consent of the Lord President of the Court of Session and the Scottish Court Service, the latter being placed under a duty to consult parties likely to have an interest. This means that the Scottish Court Service first has to consult, the Scottish ministers then make an order, and then the Lord President has to consent to the order, including further consultation with, for example, Sheriff's Principal. It is considered in policy terms that this process is bureaucratic and not well sequenced. The provisions in Section 2 of the Bill are intended from a policy perspective to make the process more straightforward. Does the committee agree to ask the Scottish Government to explain further why it considers exercise of the power in Section 2 to be a matter of the efficient organisation of the court services in Scotland, such that the negative procedure is thought to be appropriate, and given the potentially significant effect of court closures and other alterations on users of the court and the consequent implications for access to justice, whether it considers that the affirmative procedure would afford a more appropriate level of parliamentary scrutiny. Members have any comments, or are we content to ask the questions? We are. Thank you. Section 41 confers power on the Scottish ministers by order to provide that the jurisdiction of a sheriff or a specified sheriffdom sitting at a specified sheriff court will extend territorially throughout Scotland for the purposes of dealing with specified kinds of civil proceedings. Such an order may only be made with the consent of the Lord President of the Court of Session under Section 41(3). Section 41 provides that the power cannot be exercised to remove the jurisdiction of any other sheriff court to deal with the proceedings specified, nor can it be used to provide that the specified court deal with only one type of civil proceedings. The power will permit the establishment of a specialised personal injury court in Edinburgh Sheriff Court. It would also allow a similar court to be established in any other sheriff court. It would also permit the Scottish ministers to establish specialist courts for any other type of civil proceedings if it were thought in the future that there was a need to do so. The power is not limited to enabling the creation of a personal injury court in order to cater for the possibility that it will become desirable in the future to provide for further types of proceedings to be subject to all Scotland jurisdiction. Does the committee therefore agree to ask the Scottish Government to explain further why Section 41(1) proposes to confer power on the Scottish ministers to create a specialist court for types of civil proceedings other than the personal injuries proceedings? Given that the Scottish Civil Courts Review, the Government's consultation on the bill, and the policy memorandum discuss only the advantages and disadvantages of creating a specialist personal injury court, and not the advantages and disadvantages of creating any other type of specialist sheriff court, whether the power ought to be subject to a higher level of parliamentary scrutiny than the proposed negative procedure, or require consultation, or both, where it is used to create a specialist sheriff court for types of proceedings other than the personal injury proceedings, and irrespective of whether the power is used to create a specialist personal injury court or a specialist court for other types of civil proceedings, whether the affirmative procedure would afford a more appropriate level of parliamentary scrutiny, given the potentially significant effect of the creation of specialist courts on users of the courts and the implications for access to justice. Are we agreed with those questions? We are. I'm hoping folk will allow my throat a wee time out. Section 82 enables the Scottish ministers to provide by order for a sheriff to have competence to make certain types of orders, including interim orders, having effect and being capable of being enforced outside the sheriff's sheriffdom, or as well as within the sheriffdom. An order under this section may not affect interdicts or enter interdicts, as provision for these orders to have effect and to be enforced out with the sheriffdom is already set out in sections 80 and 81. The power permits the Scottish ministers to provide different provisions for different categories or descriptions of relevant orders, and to set out the circumstances, conditions and proceedings where the sheriff is to have this extended competence. Ministers may also make provision about jurisdiction in relation to the proceedings for the orders, the transfer of such proceedings, and about the enforcement of the orders made in the exercise of the extended competence of the sheriff. Does the committee agree to ask the Scottish Government why it considers that other types of orders, apart from interdicts and interim interdicts, might benefit from having effect and being capable of being enforced outside the sheriffdom in which they were made? Section 93 of the bill sets out the scope for permitting lay representation on behalf of non-natural persons, that is, companies, partnerships and other corporate bodies, in non-simple procedure cases in the Sheriff Court, the Sheriff Appeal Court and the Court of Session. The decision on whether to permit lay representation lies with the court, who may grant permission where the conditions in subsection 3 are satisfied. These are that the non-natural person is unable to pay for the services of a legal representative to conduct the proceedings, the lay representative is a suitable person to conduct the proceedings to be assessed in the light of subsection 4, and that it is in the interests of justice to grant permission. In deciding whether it is in the interests of justice, the court must have regard in particular to the non-natural person's prospects of success in the proceedings and the likely complexity of the proceedings. Section 94(1) enables the Court of Session to make further provision, by Act of Subordinate A, about granting permission under Section 93, and B, about the conduct of proceedings by lay representatives. Subsection 2 contains an illustrative list of the matters which provision under subsection 1 may include. Does the committee agree to ask the Scottish Government to explain the following? Whether the power in Section 94(1)A is intended to enable provision to be made only about the procedure for granting permission under Section 93, or whether it is intended to add to the provision in Section 93(3) in some substantive way, and if it is the former, why is the power drawn more widely than that, and if it is the latter, why is it considered appropriate to confer the power on the Court of Session to be exercised by Act of Sederant? Thank you. Section 96 provides powers for the Court of Session to make rules of court by Act of Sederant to regulate practice and procedure in the Court of Session. It replaces Sections 5 and 5A of the Court of Session Act 1988, hereinafter referred to as the 1988 Act, with a new Section 5. Section 5(1) contains a broad, general power to make provision regarding procedure and practice. Subsection 2 contains specific illustrative examples of the sort of matters which are procedure and practice for the purposes of this power, including the conduct and management of proceedings in the Court of Session, the form of documents used, appeals against decisions, awards of expenses, and the representation of parties by those otherwise not qualified to do so. Given the width of subsection 1, subsection 2 is not intended to be exhaustive and as expressly provides that subsection 1 is not limited by the specific examples of the power in subsection 2. Subsection 3 allows these acts as sederant to make various types of ancillary provision, and subsection 4 clarifies the new powers do not affect any existing power to make court rules. Section 97(1) provides a broad power for the Court of Session to make rules of court by Act of Sederant to regulate practice and procedure in civil proceedings in the Sheriff Court and the Sheriff Appeal Court. It is a replacement for the power in Section 32 of the Sheriff Court Scotland Act 1971, insofar as rules of the Sheriff Court are concerned, with an extension of the powers to enable provision to be made about the new Sheriff Appeal Court. Subsection 1 contains a broad general power to make provision regarding procedure and practice. Subsection 2 contains some specific illustrative examples of the sort of matters which are procedure and practice for the purposes of this power, including the conduct and management of proceedings in the Sheriff Courts and the Sheriff Appeal Court, the forms of documents used, appeals against decisions, awards of expenses, and the representation of parties by those otherwise not qualified to do so. Given the width of subsection 1, subsection 2 is not intended to be exhaustive, and it expressly provides that subsection 1 is not limited by the specific examples of the power in subsection 2. Examples given are broadly similar to those contained in the equivalent power to make rules for the Court of Session, but with some variations reflecting the different jurisdictions of the courts. In relation to Section 96 and 97(1), does the committee agree to ask the Scottish Government to explain the limits of the powers in the new Section 5(1)B of the 1988 Act and Section 97(1)B of the Bill to make provision for or about any matter incidental or ancillary to such proceedings, whether the powers permit the Court to make provision in relation to matters other than the procedure and practice of the Court of Session, the Sheriff Court and the Sheriff Appeal Court, including issues of substance which arise in those proceedings, in what way the powers in new Section 5(1)B of the 1988 Act, as inserted by Section 96 in respect of the Court of Session and Section 97(1)B in respect of the Sheriff Court and the Sheriff Appeal Court, differ from the powers in new Section 5(3) and Section 97(4) of the Bill, respectively, to make incidental, supplemental, consequential, transitional, transitory and saving provision in any act of sederant made under those sections, and why separate provision to that effect is required, whether the provision which may be made by virtue of the new Section 5(3) of the 1988 Act or Section 97(4) of the Bill is limited to such provision as is necessary or expedient for the purposes of the act of sederant in question, or whether it extends more broadly to make general incidental provision, and if so, to what it might be incidental. And lastly, whether the power in Section 5(1) of the 1980 Act or Section 97(1) of the Bill would permit the court to regulate proceedings for contempt of court arising in civil proceedings, or whether specific provision would be appropriate to make this clear. Are we so agreed? We are. Thank you. Section 34 and 35 are new provisions which implement the recommendations of the Scottish Civil Courts Review in relation to the desirability of greater specialisation in sheriff courts. Section 34 permits the Lord President to determine, by direction, categories of cases within the sheriff courts which should be heard by judicial officers who specialise in that category of case. The categories may be determined by subject matter, by value, or other criteria as the Lord President considers appropriate. Does the committee agree to ask the Scottish Government for clarification as to why Section 34 does not provide that these directions may be issued under section required to be published, and what the intentions are in relation to publication? We do. Thank you. That concludes item 6, and I move this meeting into private.